So this is the part 2 of general exceptions. So in my previous video we have learned section 76 to 79 of IPC, and if you see the section of Bharatiya न्याय Sanhita, it was section 14 to 17. So today we will learn section 80 to 95 of IPC, and the section of Bharatiya न्याय Sanhita is 18 to 33. So let's see all the section one by one. So section 80 of IPC and section 18 of Bharatiya न्याय Sanhita talks about accident in doing a lawful act. So it says that nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. So these sections provide immunity from criminal liability when an act results in harm due to an accident or misfortune. But the act must be lawful without criminal intention or negligence. So if you see the ingredients of these sections, it talks about lawful act in lawful manners by lawful means. So the ingredients of this section would be the act must be lawful. So the act that cause harm must be lawful in itself. If the act is prohibited or unlawful, this sections does not apply. The second ingredient is the act must be done in lawful manner. So the manner of performing the act must comply with the legal norms and standard. And even if the act is lawful, performing it carelessly or recklessly may negate the protections. So firing a gun at a shooting range in compliance with all the safety protocols is lawful, but firing recklessly without observing protocol is not. So the act must be lawful in lawful manner with lawful means. The fourth ingredient is without criminal intention or knowledge. So the harm caused must not result from intentional or prior knowledge of the likelihood of harm. So criminal intention and knowledge of harm negate the defense of accidents. Suppose if the person fires a gun with the intent to scare someone and accidentally kills them, section 80 does not apply. And lastly, it says that the act must be done with proper care and caution. So the individual must take reasonable precautions to prevent harm while performing the act. Negligence or lack of cautions disqualify the act from being considered an accident. So let us see one case law. The case name is Tunda versus Rexley. So the fact of the case is the accused fired a gun for defense during a lawful demonstrations, but the bullet accidentally hit someone. So the court held that since the act was done lawfully without intent and with due care, it was covered under section 80. So this sections provides immunity to accidental act only. The absence of criminal intent or negligence is critical, and care and caution requirement is necessary. So the immunity applies only when the individual takes reasonable precautions to prevent harm. Unlawful acts are not covered under these sections. Negligence, intentional or reckless acts are not covered. So this is all about section 80. So let us see section 81. It talks about acts likely to cause harm but done without criminal intent and to prevent other harm. So here this section reflects the principle of necessity, where an otherwise unlawful act is justified if it is done for the purpose of preventing greater harm. So it provides protection to a person who causes harm while performing an act that was done without criminal intent. That is, the act was not performed with a motive to cause harm or without any criminal intention, and it is done for greater good. That is, the harm caused was to prevent or avoid greater harm to a person or property. So let us see the ingredients of this section one by one. First is the knowledge of harm. So it says that the person committing the act is aware that the act might cause harm, and the absence of criminal intent must be there. So the act must be free of any criminal intention, malice or ill will, and the purpose to prevent or avoid harm. So the act should have been performed to prevent greater harm to life, property or society. And lastly, there should be a reasonable necessity. So there must be a reasonable necessity for the act, and it should not be an excuse for recklessness. So this section highlights the balance between individual right and the larger public good, and harm caused must be proportional to the harm sought to be avoided. So even slight evidence of malice may disqualify protections under this sections. So one case law, so the case name is R versus Titley and Stephen. So this is a famous case where it states that 4 men were lost in a high sea with no food and water after several days. So the captain Titley and first mate Stephen decided to kill and eat the cabin boy Parker. So Parker was the weakest and he was severely ill. So the 4th crew member Brooke did not partake in killing Parker, but he ate the boy's flesh. But after 4 days, they were rescued, and upon reaching England, Titley and Stephen was charged with murder. So they argued that their action were done out of necessity and it was the only way to survive. So here the court rejected the defense of necessity and convicted under murder, but later, due to their unique nature of case, the death sentence was commuted to 6-month imprisonment. Though it is an English case, it explains the principle of necessity, where an act causing harm may be excusable if it prevents greater harm, but taking an innocent life deliberately cannot be justified even under the most extreme circumstances. So this is one of the important case law of section 81. So if we compare section 80 and 81, section 80 applies to accidental act without intent, and section 81 applies to intentional act done to prevent greater harm. So let us see section 82. So it talks about act of a child under 7 years of age. So nothing is an offense which is done by a child under 7 years of age. So this section established the principle of absolute immunity for children under the age of 7 years, and it recognized that children in this age group lack the maturity of understanding. So it is based on the legal doctrine of Dolly in capex, which means incapable of crime. So the child below 7 years lacks the intellectual capacity to understand the consequences of their actions, and the moral understanding to distinguish between right and wrong is absent in the child below the age of 7 years. The ingredients is it should be the age below 7 years. They provide complete immunity for criminal liability and irrespective of the nature of the act they commit. So this is all about section 82. So section 83 talks about act of a child above 7 years and under 12 years of immature understanding. So section 83 provides conditional immunity to children aged below 7 to 12. So unlike section 82, which has grant absolute immunity to children under 7 years, this section requires an assessment of the children's mental maturity. So it recognizes that children in this age group may sometimes lack the capability to understand the nature and consequences of these actions. So if we compare section 82 and 83, the age group is in section 82 it is below 7 years, in section 83 it is 7 to 12 years. So type of immunity here in section 82 it is absolute, no evidence can retribute, where in section 83 it is conditional based on the maturity assessment. Menstruation, so it is presumed absent in section 82, whereas it is assessed based on the child's understanding. So the key principle is Dolly in capex is absolute in this section, whereas the maxim Dolly in capex is qualified in this sections. So let us see section 84. It talks about act of a person of unsound mind. So these sections provide immunity from criminal liability to a person who commits an act due to unsoundness. So the person lacks the mental capacity to understand their actions or distinguish between right or wrong and cannot form a necessary mens rea. So let us see the ingredients of this section. So the ingredients of this section is unsoundness of mind. So the person must be suffering from unsoundness of mind, that is insanity or mental disorder, at the time of committing the act. And incapacity to understand is the second ingredient. So due to unsoundness of mind, the person is incapable of knowing the nature of the act or realizing that the act is wrong or contrary to law. And at the time of the act is the third ingredient, which says that the unsoundness of mind must exist at the time of committing the offense and not before or after the act. So and the timing of insanity is critical in these sections, that whether the person was insane at the time of committing the offense. So past or future insanity does not qualify in these sections. So at the time of doing the act, the person must be unsound mind. So this section is based on the legal principle derived from maxim Nocton. So Daniel MC Nocton was a Scotsman. He was desirous of committing the murder of PM of England, named as Sir Robert Peel. So one day he took a gun and shot at Edmund Dormant, who was a secretary of Sir Robert Peel. So he did it under an insane delusion that he is killing Sir Robert Peel. So MC MacDonald was tried for killing Dormant. The defense of insanity was pleaded by producing medical evidence. So he was acquitted on the ground of insanity. So the judges have given 5 rules and they are called MC Nocton rules. So the first rule is, in the defense of insanity, the accused must prove that he was insane at the time of committing the crime. Second is, every person is presumed to be sane and possess capacity to commit a crime. Third is, the medical evidence must be by such a doctor who has not seen the accused previously to the trial of the case. Fourth is, every accused must be presumed to be innocent until the guilt is proved. And fifth is, the immediate consequences and surrounding facts of the crime must also be taken into considerations. So these are the 5 rules derived from MC Nocton case, and this is important for this section of unsound mind. Let us see section 85. This section talks about act of a person incapable of judgment by reason of intoxication caused against his will. So these sections provide conditional immunity to a person who commits an offense under involuntary intoxications. The rationale is that such person lacks the capacity to understand the nature of the actions or distinguish between right or wrong due to intoxications beyond his control. So the first ingredients would be involuntary intoxications. So the intoxication must have been caused without the person's knowledge or against their will. Example, forced consumption of some drink, alcohol or drugs is the involuntary intoxications, but self-induced by drinking alcohol or drug does not provide immunity. And the second ingredients would be incapacity to understand. So the person must be incapable of knowing the nature of the act or realizing that the act is wrong or contrary to law. And the third would be at the time of the act. So intoxication must render the person incapable at the time of committing the offense. In this section, you should know the difference between voluntary and involuntary intoxications, where voluntary is self-induced by drinking alcohol or drugs by himself, whereas involuntary is the person is unaware about the consumption of drugs or alcohol. Section 86, so it says that offense requiring a particular intent or knowledge committed by one who is intoxicated. So this provision ensures that voluntary intoxications cannot be used as an excuse for escaping criminal liability, whereas in section 85 there was involuntary intoxications. Here it is voluntary intoxication. So it creates a distinction between voluntary and involuntary intoxication. So voluntary is self-induced, whereas involuntary is caused without the person's knowledge. Let us see the difference between these two sections. Here it is involuntary intoxication, that is without that person's knowledge. Here it is voluntary intoxication, that is self-induced intoxications. So here immunity is provided. Here it is not provided due to presumption of mens rea is present. So the burden of proof is on the accused that involuntary intoxication was there, whereas prosecution assumes mens rea unless disproved in this section. So this is a landmark case of section 85 and 86. It's a Director of Public Prosecution versus Beard. So here, Beard was a watchman at the gate of a mill. He was seeing a girl of 13 years going to the market every day. So Beard attempted to commit rape on the girl, and the girl struggled and cried. Beard, in order to prevent her from shouting, put his hand over her mouth and pressed his thumb on the throat of the girl. So the girl died of strangulations. So here, Beard pleaded defense of drunkenness and insanity, but the court held that he is liable to be convicted for murder. In case of voluntary drunkenness, the person will be deemed to be of the same knowledge as it is not intoxicated. So, as I said, section 86 provides voluntary intoxications where it does not provide immunity due to presence of mens rea. So here, Beard's intention was to rape a girl, and it was a voluntary drunkenness, so he was liable for murder and rape. So section 87, it says that act not intended and not known to be likely to cause death or grievous hurt done by consent. These sections provide legal immunity to acts that involves consent between adults, that is a person who is above 18, where harm is neither intended to cause death or grievous hurt. The person giving consent is fully aware of the risk and consequences. So the ingredients of this section should be, so the first ingredient is consent given by a person above 18 years. So person giving consent must be 18 years and above, and it can be express or implied. So express consent is stated, whereas implied consent is understood from conduct. The second ingredient would be act without intention to cause death or grievous hurt. So the act should not be intended to cause death or grievous hurt, and if the person knows the act is likely to cause death or grievous hurt, section 87 will not apply. Third is awareness of risk. So the person giving consent must be fully aware of the harm or risk associated with the act. And fourth is voluntary consent. So the consent must be given freely without coercion, fraud, or mistake. The acts which are covered under these sections are of sports, recreational activities like boxing, wrestling, or martial art, medical treatment or procedures, surgical operations, or treatment where patient's consent is needed, and adventurous activities like skydiving, mountaineering. So these are the activities that are covered under these sections. Section is based on the principle of voluntary non-fit injury, which says to a willing person no injury is done. It talks about act not intended to cause death done by consent in good faith for person's benefit. So this section deals with the act not intended to cause death done by consent in good faith for the benefit of a person. So this sections primarily safeguard actions done in good faith for the benefit of an individual with their consent, even if the actions result in harm, provided they were no intention to cause death. So the ingredient of this section would be act not intended to cause death. So the act in question must not be intended to cause death. If there is an intention to cause death, this section will not apply. Second is consent of the person. The person who suffers harm must express or impliedly give a consent. X is a stated consent, whereas implied is through a person's conduct. And third is done in good faith. So the doer genuinely believed that the action would be benefited for the person. Fourth is for the benefit of the person. So act must be, as I said, the act must be performed for the benefit of the person giving consent, such as medical procedure or acts to save someone from harm. So this is section 88. Section 89 talks about act done in good faith for the benefit of child or innocent person by or by consent of guardian. So nothing. So here, this section deals with the act done in good faith for the benefit of child or a person of unsound mind, and with the consent but without intending to cause death or grievous hurt. So it provides immunity to caregivers, guardians, and other acting for the welfare of minor or individuals incapable of giving valid consent. So the act must be done honestly without a genuine belief that it is for the benefit of the person under care. And the act must be aimed at improving the physical or mental condition of the minor. Minor means less than 12 years or of unsound mind. And if the person is incapable of giving consent, the act must be done with the express or implied consent of guardian or caretaker. And the immunity does not extend to the act that intentionally causes or are likely to cause death or grievous hurt. So here it provides a legal safeguard to caregivers acting in good faith, ensuring that their well-meaning actions are not unfairly criminalized. So Section 90 talks about consent known to be given under fear or misconception. So here, this section defines the condition where consent given is not free consent. It's not valid, and thus it cannot be used as a defense. So consent under fear or misconception is not valid. So if a person agrees to sign a document under threat of violence, so it is not a valid consent. Here, misconception of fact means consent given under a false belief and is also invalid. So suppose if a man induce a woman to have sexual intercourse by falsely promising marriage, so if the promise was made without the intention of fulfilling it, constitute misconception of fact. And if a person, so section 81 talks about exclusion of act which are offenses independently of harm caused. These sections ensure that even if a person consents, certain acts remain punishable because they inherently violates public policy or social norms. So the ingredients of this section would be acts that are offenses regardless of consent. So certain acts are inherently criminal in nature and consent cannot legalize them. These acts are punishable regardless of whether they result in harm or the person affected consent to them. So abetment of crime, unnatural sexual offenses comes under this section. So second is independent criminal offense. So this section applies when the act in question constitute an offense independently, even without reference to consent or harm caused. Exclusion of section 87, 88 and 89 is there. So the defense available under these sections do not apply if the act is inherently an offense. So as illustration is given, causing miscarriage. So unless caused in good faith for the purpose of saving the life of the woman is an offense independently of any harm which it may cause or be intended to cause to the woman. These acts are punishable regardless of whether they result in harm or the person affected consented to them. So the offenses like abetment of crime, unnatural sex, miscarriage, these are the act that is inherently an offense. Now section 92 talks about act done in good faith for benefit of person without consent. So sections provide immunity for criminal liability for act done in good faith for another person's benefit even without that person's consent. And this section is closely related to section 88 and 89, but it applies specially when consent cannot be obtained and the act is done in good faith for the person's welfare. So the ingredients of this section would be good faith. So it must perform with honest intention for benefit of individual. So the benefit of the person must be there. So the act must be directed towards promoting the well-being of the persons concerned. So third is impossibility of consent. So it applies only when obtaining the person consent is impossible and no intention to cause death. So act should not be intended to cause death. So in these sections, the act is performed by the stranger. So unlike section 89, which applies to act done for minor or person of unsound mind by their guardian, section 92 extends to act performed by stranger or non-relatives. So section 93 talks about communication made in good faith. So no sections provide individuals who is in good faith communicate something for another's benefit, even if such communications causes harm to the recipients. So the key idea is that the communication must be made with honest intention and for the recipient's welfare and not to harm them maliciously. So let us see section 94. It talks about act to which a person is compelled by threat. So this section ensures that the individual who act in self-defense or defense of another are not subject to criminal liability, and it applies both bodily harm and property. So it allows individual to use reasonable force to protect themselves against assault or threat, as well as to prevent the theft or damage of their property. So if an individual is assaulted by another person and uses reasonable force to defend themselves, such as pushing the assailant away or striking back in order to escape, these actions are protected. And protecting a third party is also there. Suppose if the intervenes to protect someone being attacked, uses reasonable force to prevent the assault, their actions are also justified. So nothing is an offense which is not intended to cause harm, and the harm is so slight that no person of ordinary sense and temper would complain of such harm. So this was the last section of this video. Thank you for watching, and in part 3 we will talk about right of private defense. So thank you for watching.